Right now, inside a Texas courtroom, the woman seated at that table is Catherine Welch. This isn't a story about a first mistake or even a second one. This marks her 10th DWI on record, and the consequences are serious. She faces a possible sentence of 25 years to life. The twist? Her defense attorney isn't asking for a slightly shorter prison term. Instead, he's making an unusual plea: probation. That request is rare in cases with this many prior offenses, and it immediately shifts the tone of the hearing that you'll see two very different portraits offered to the judge. The defense painting a path toward accountability and recovery, and the prosecution arguing that public safety must come first. The judge now stands in the middle, balancing the promise of second chances against the need to protect the community. Expect sharp legal arguments, emotional testimony, and a courtroom that feels like the front line of a difficult moral question. The decision at the end will surprise many, and I'll take you through the judge's reasoning point by point, so nothing is missed. Watch closely. Every comment, every objection, and every ruling matters.
All right, this is cause number 24, DCCR 0122, State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while...
From the very start, Catherine Welch's guilty plea shifts the entire atmosphere of the courtroom. There's no debate over what happened. She admitted to it, plain and simple. In legal language, this is what's known as a plea without a sentencing agreement. That means there are no backroom deals or prearranged outcomes. The judge alone holds all the power in deciding her fate, that it's a risky move, almost like rolling the dice in a high-stakes game. With a felony DWI on her record, and the charge boosted even further by multiple past convictions, the possible punishment stretches across a wide spectrum. The outcome could range from a second chance to decades behind bars. That weight hangs in the room long before the defense even begins to argue their case. And everyone present knows the decision handed down here will have consequences that reach far beyond today's hearing.
Intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum. So
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Malfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well?
same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think our focus here is going to be on the topics that we talk about or write about in the sentencing memo, and just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well.
Here's an important legal detail worth noting. The Dream Center is a faith-based recovery program, and bringing it up in court is more than just a name drop. It's a clear signal that the defense wants to focus on treatment and rehabilitation instead of prison time. Judges are well aware of these types of programs and what they offer, but there's an undeniable reality. A good program can't simply wipe away a long track record of poor decisions. Still, by having someone from the Dream Center prepare to testify, the defense is carefully planting an idea. They're saying, look, she won't be alone if given another chance. There's a structured support system waiting to step in. It's an attempt to show that Catherine's future could look different if the court allows it. The big question, though, is whether that seed of hope will actually take root. For it to grow into real leniency, the defense must deliver a persuasive, well-rounded argument strong enough to outweigh her troubled past.
An option that doesn't cost the court anything,
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No.
All right, then argument.
Judge, I want to
Pay close attention to how the defense is building its case. They aren't trying to gloss over Catherine's past. If anything, they're putting it on the table and then pivoting hard toward her alleged transformation. They highlight her time in inpatient rehab, participation in trauma therapy, attendance at AA meetings, and even voluntary drug testing to prove accountability. It's a calculated approach meant to show real, measurable progress. From a legal psychology standpoint, this kind of evidence can matter. Judges often take note when someone demonstrates consistent effort over an extended period, especially if it's backed by documentation rather than empty promises. It signals a genuine attempt to change course, not just a last-minute performance for the courtroom. But here's the tension that can't be ignored. Effort doesn't automatically eliminate risk. 9 prior convictions don't just vanish because of a 3-year clean stretch. The defense is essentially asking the court to believe that this time, the change is permanent. Whether that belief takes hold is the fine line they're trying to walk.